Excuse me. I'm gonna start this reading. I want to read this kind of declare. Yeah, I want to read this for myself. Bad. So it's the Conveyance Act. Conveyance Act. Let's see. The Conveyance Act. Excuse me. I'm not going to read all this. I'm going to scroll through. Let me see. The Conveyance Act, 1st December 1889. This is Chapter 73, Law 51 of 1957, Act 1 of 1979, First Schedule, short title. This act may be cited as the Conveyancing Act. Preliminary. Nothing in this act shall apply to land brought under the operation of the Registration of Titles Act. Limitation, interpretation. In this act, property, unless a contrary intention appears, includes real and personal property, and any estate or interest in any property, real or personal, and any debt, and anything in action, and any other right or interest in the nature of property, whether in possession or not. Land, unless a contrary intention appears, includes land of any tenor, and tenements, and hereditaments, corporeal or incorporeal, and houses and other buildings, also an undivided share in land. Income in relation to land includes rents and profits, and possession includes receipt of income. Conveyance, unless a contrary intention appears, includes assignment, appointment, lease, settlement, and other assurance, and covenant to surrender made by deed on a sale, mortgage, demise, or settlement of any property, or on any other dealing with or for any property, and convey, unless a contrary intention appears, has a meaning corresponding with that of conveyance. Conveyance. Mortgage includes any charge on any property for securing money or money's worth, and mortgage money means money or money's worth secured by mortgage or mortgager. Includes any person from time to time deriving title under the original mortgagor, or entitled to redeem a mortgage according to his estate, interest, or right in the mortgage property, And mortgagee includes any person from time to time deriving title under the original mortgagee. And mortgagee in possession is, for the purpose of this act, a mortgagee who, in right of the mortgage, has entered into and is in possession of the mortgage property. Encumbrance includes a mortgage in fee or for less estate, and a trust for securing money, and a lien, and a charge of a portion, annuity, or other capital or annual sum. And encumbrancer has a meaning corresponding with that of encumbrance, and includes every person entitled to the benefit of an encumbrance, or to require payment or discharge thereof. Includes a mortgage in fee or for a less estate, and a trust for securing money, and a lien, and a charge of a portion, annuity, and other capital. Purchaser includes a leasee or mortgagee, or an intended purchaser, leasee, or mortgagee, or other person who, for valuable consideration, takes or deals for any property, and purchase has a meaning corresponding with that of purchaser. Rent includes yearly or other rent, toll, duty, royalty, or other reservation by the acre, the ton, or otherwise. And fine includes premium or for gift, and any payment, consideration, or benefit in the name of a fine, premium, or for gift. Building purposes includes the erecting and the improving, the erecting and the improving of, and the adding to, and the repairing of buildings. And a building lease is a lease for building purposes or purposes connected therewith. And a building lease is a lease for building purposes. Mining lease is a lease for mining purposes. That is the searching for, winning, working, getting, making, merchantable, carrying away, or disposing of mines and minerals for purposes connected therewith, and includes a grant or a license for mining purposes. Will includes codicil. Instrument includes deeds, wills, and statute at law. Securities include stocks, funds, debentures, and shares. Bankruptcy includes liquidation by arrangement and any other act or proceeding in law having under any enactment for the time being in force, effects, or results similar to those of bankruptcy, and bankrupt has a meaning corresponding with that of bankruptcy. Writing includes print and words referring to any instrument, copy, extract, abstract, or other document, including any such instrument, copy, extract, abstract, or other document being in writing or in print, or partly in writing and partly in print. Person includes a corporation. Person includes a corporation. The Supreme Court is referred to as the court. The court. Old practice retained as to preparation, investigation, etc. of documents. Nothing in this act contained shall be taken to alter the practice theretofore existing in this island, and conveyancing, by which were there is no agreement to the contrary, the following conditions always attach. Nothing in this act contained shall be taken to alter the practice theretofore existing in this island, in conveyancing, by which were there is no agreement to the contrary, the following conditions always attach. The attorney at law of the vendor, lessor, or mortgagee has the right to prepare and complete the conveyancing, lease, or mortgage. The attorney at law of the vendor, leaser, and mortgagee has a right to prepare and complete the conveyancing, lease, or mortgage. The purchaser or leasee pays to the vendor or leaser one half of the vendor's or leaser's costs so incurred, including stamping the conveyance or lease, and in the case of a lease, of recording it also. The purchaser records his conveyance at his expense. The vendor perfects his title on the record at his own expense. The mortgagor pays all the costs of the mortgage, including all of the mortgagee's costs for investigating the title and stamping and recording the mortgage. The purchaser on a sale examines into the vendor's title and approves of the conveyance at his sole cost. No vendor is required to give to a purchaser any abstract of title, but in submitting the draft conveyance, he furnishes the purchaser's attorney at law with any information he may have of the title. 2. Sales and other transactions. Notice, a purchaser shall not be prejudicially affected by notice of any instrument, fact, or thing, unless prejudicially. A purchaser shall not be prejudicially affected by notice of any instrument, fact, or thing, unless it is within his own knowledge or would have come to his knowledge if such inquiries or inspections had been made and ought reasonably to have been made by him, or in the same transaction with respect to which a question of notice to the purchaser arises, it has come to the knowledge of his counsel as such, or of his attorney-in-law and other agent as such, or would have come to the knowledge of his attorney-at-law or other agent as such, if such inquiries or inspections had been made as ought reasonably to have been made by the attorney-at-law and other agent. 2. This section shall not exempt a purchaser from any liability under or any obligation to perform or observe any conveyance, condition, provision, or restriction contained in any instrument under which his title is derived, mediated, or immediately, and such liability or obligation may be enforced in the same manner and to the same extent as if this section had not been enacted. 3. A purchaser shall not by reason of anything in this section be affected by notice of any case where he would not have been so affected in this section had not been enacted. This section applies to purchases made whether before or after the commencement of this act, save that where an action is pending at the commencement of this act, the right of the parties shall not be affected by this section. Contract for sale. Under a contract for sale and assign a term of years derived out of the leasehold interest in land, the intended assigned shall not have the right to call for the title to the leasehold reversion. Application of stated conditions of sale to all purchases. Under a contract to sell and assign a term of years derived out of the leasehold interest in land, the intended assigned shall not have the right to call for the title to the leasehold reversion. A purchaser of any property shall not require the production or any abstract or copy of any deed, will, or other document dated or made before the time prescribed by law or stipulated for commencement of the title, even though the same creates a power subsequently exercised by an instrument made up the vendor's claim of title. Nor shall he require any information or make any requisition, objection, or inquiry with respect to any such deed, will, or document, or the title prior to that time, notwithstanding that any such deed, will, or other document, or that prior title is recited, covenanted, to be produced or noticed, and he shall assume, unless the contrary appears, that the recitals contained in such instrument of any deed, will, or other document forming part of that prior title are correct, and give all of the material consents of the deed, will, or other documents so recited, and that every document so recited was duly executed by all necessary parties and perfected, if and required by fine, recovery, acknowledgement, enrollment, or otherwise. Where land so is held by lease, not including under lease, the purchaser shall assume, unless the contrary appears, that the lease was duly granted, and on production of the receipt for the last payment due for rent under the lease before the date of actual completion of the purchase, he shall assume, unless the contrary appears, that all the covenants and provisions of the lease have been duly performed formed and observed up to the date of actual completion of the purchase. Where land sold is held by under lease, the purchaser shall assume, unless the contrary appears, that the under lease and every superior lease was duly granted. And on production of the receipt for the late payment due for rent under the under lease before the date of actual completion of the purchase. he shall assume, unless the contrary appears, that all of the covenants and provisions of the under lease have been duly performed and observed up to the date of actual completion of the purchase, and further, that all rent due under every superior lease and all the covenants and provisions of every superior lease have been paid and duly performed and observed up to that date. On the sale of any property, the expenses of the production and inspection of all statutes, whether of Jamaica or of the United Kingdom, records, proceedings of court, deeds, wills, probates, letters of administration, and other documents not in the vendor's possession, or the expense of all journeys incidental to such production or inspection, and the expenses of searching for, procuring, making, verifying, and producing all certificates, declarations, evidences, and information not in the vendor's possession, and all attested, stamped, office, or other copies or abstracts of or extracts from any statutes or other documents aforesaid not in the vendor's possession, if any such production, inspection, journey, search, procuring, making, or verifying is required by a purchaser, either by verification of the title or of any abstract delivered, or for any other purpose, shall be borne by the purchaser who requires the same, and where the vendor retains possession of any document, the expenses of making any copy thereof, attested or unattested, which a purchaser requires to be delivered to him, shall be borne by that purchaser, provided that the vendor may not retain any document relating only to the title of the property sold, provided also that nothing in this subsection shall restrict the purchaser's rights to require at the expense of the vendor the enrollment in the public office, in the record office of all instruments necessarily making up his vendor's title for the period during which the vendor is required by law or by agreement to make title. This section applies only to titles and purchases on sales properly so called, notwithstanding any interpretation in this act. This section applies only if and as far as a contrary intention is not expressed in the contract of sale, and shall have effect subject to the terms of the contract and to the provisions therein contained. This section applies only to sales made after the commencement of this act. Nothing in this section shall be construed as binding a purchaser to complete his purchase in any case where, on the contract made independently of this section and containing stipulations similar to the provisions of this section, or any of them specific performance, and the contract would not be enforced against him by the court. Where at the death of any person there is subsisting a contract enforceable against his heir or devicee for the sale of the fee simple or other freehold interest, decedentable to his heirs general, and any land his personal representatives shall, by virtue of this act, have power to convey the land for all the estate and interest vested in him at his death in any manner proper for giving effect to the contract. A conveyance made under this section shall not affect the beneficial rights of any person claiming under any testamentary disposition, or as heir or next of kin of the testator or intestate. This section applies only in cases of death after the commencement of this act. When we come back, we're going to have discharge of encumbrances on sale.